had a fair use defense in them, notwithstanding Campbell versus Acuff Rose. And I just started this project this summer, but it's actually an issue that's been bugging me for about 15 years. I can sort of date it back to when I first started thinking about this issue, all the way back to Stanford, when I was a fellow there, and I had the pleasure of auditing Paul Goldstein's copyright class at Stanford, and we went through the music infringement cases, and all of you in the room who taught copyright, it's a really fun set of cases to go through. One thing that struck me about those cases is that none of the defendants raised a fair use defense. So I asked Paul, why is that the case? And Paul said, great question. I think that's what he said. That's my story. And his explanation was that fair use originated in the context of literary works, and historically it had text as the basis for which the doctrines were developed. And that was his initial reaction to the question. So I sort of left it at that, and I had other things that I was working on. And I would not be writing this paper at all were not for this case that occurred this past year, in which Pharrell and Robin Thicke sued in a declaratory judgment action the copyright owners to the copyright for Marvin Gaye's documented off the musical composition. And they asserted that this was not infringement, but made no alternative argument that nonetheless it should be considered fair use if there was infringement found. So that sort of rekindled my interest in this topic to study sort of this general issue about music fair use, and why we don't see fair use in music cases that often, or at least that's my perception of the cases and based on the decisions in the music infringement cases. Now, what would the fair use argument look like in the Pharrell case? Now, disclaimer is I don't read sheet music. I did when I was 8, and I should have listened to my mom about piano lessons and stuck with it. But some of you in the room read music, and maybe you can correct me if I'm wrong. I get some help from my research assistant and reading online, who's a musician, and reading online some other analysis by musicologists about this case. It turns out if you read the compositions of both works, the actual notes don't have many identical notes in them. So it's not a strong case for literal infringement, if you want to use that term in the context of this composition. It's, the case would be non-literal infringement, or there's some literal infringement, but very small portions. So to focus on one aspect of the similarities, it was pointed out that the melodies bear some resemblance in the pattern. This so-called 3-3-2 sharp 3 pattern is in the last 30 seconds of the Marvin Gaye composition, and in the Pharrell composition is a little bit earlier, and I think recurs at various points in the Pharrell song. One thing to note is that at the bottom here, this slide indicates that the actual songs are written in 2 different notes. So it's actually A major in Marvin Gaye's composition, G major in Pharrell's composition, but for this purpose, I borrowed somebody else's analysis. The Pharrell composition is transposed into A major to make them seem the strongest case that there is a similarity. So if we made this into a fair use argument, the argument I think would sound something like, well, Pharrell, we've copied this sequence, but we've transformed it, given it a new meaning in G major, plus most of the notes in the composition itself are different from the actual composition of Marvin Gaye. Now, it may be a loser argument, but I think it's at least a colorful argument that could have been raised in the case, and there are a bunch of fair use cases in which fair use was rejected in other contexts where, at least you can understand they made an attempt at the argument for transformative use under the Acuff Rose sort of doctrine. Now that goes back to the general question that has bugged me for these past 15 years, and that's the study that I'm undertaking right now. How often does fair use occur in musical work cases of infringement? And just to be clear on the type of cases that I'm really concerned about, is when you have a subsequent musical work that is alleged to have infringed the musical work of an earlier copyright. And then the defendant raises the defense that if I copied, then the portion that I've copied, I have made a fair use of the earlier work, based on, hopefully the argument would be transformative use. Now my hypothesis is that this defense occurs far less frequently in the context of musical work infringement cases, but perhaps more often raised in the district court, in pleadings, and I'll get to that a little bit later when I talk about the research. I've done a little bit of research to help me sort of formulate what my hypothesis is. Now, assuming this hypothesis is correct, why might this be the case for musical works as opposed to other types of works? Well, it could be that defendants are actually prevailing on other grounds of non-infringement, no substantial similarity, de minimis, the element was not even copyrightable. So that's a possibility. It wouldn't explain, actually, the cases the defendants lose, and there are certainly some cases in which defendants have lost for musical work infringement cases. Secondly, that's a typo. Secondly, defendants might be foregoing fair use defenses entirely, or at least at some point in litigation it just drops out. They don't pursue it. And thanks to Peter DePaul for suggesting that there may be a culture in the music industry where this is just not a part of how established musicians and the studios and labels operate. This is not a part of their culture. So that's why it's not being invoked. And then third and finally would be it's a loser argument and there's a really bad precedent out there. Actually, I don't think that this explains it, because I don't think there's a really bad precedent that forecloses a fair use defense from being raised. But that's another possibility, is that there's enough bad law out there so that litigants, even if they thought that it could be raised, it's just such a poor argument, it won't win, and they know not to bring it. Now, I've done a little bit of review of the case law in terms of reported decisions on Westlaw, and Barton Beebe was gracious enough to allow me to look at his survey of all the fair use cases, decisions out there. And I've done Westlaw research to supplement Barton's survey, and so far as I can tell, there are just 4 fair use decisions involving musical work cases. Everybody knows Campbell. There were 2 other parody cases. There's actually a pretty recent 2009 non-parody case, and I would expect there to have been more of these involving George Clinton's Atomic Dog. And there was no fair use of George Clinton's composition by Little Bow Wow in this hip-hop song, so that rejected the fair use defense in that particular case. Now, how am I going to go about looking at this issue? So a lot of the point of the paper is just to confirm this description that this is actually accurate of assessment of what's going on. The first part of the study will focus on decisions, so looking in Westlaw and going through all of the musical work infringement cases. What I've done so far is looked at appellate cases, roughly 40 that have involved the 1976 Act. I haven't gone back to the 1999 Act, but I could at one point if it turns out the data is interesting on this level, and maybe the 1999 Act had sort of different results. But so far it's just 1976 Act and 40 appellate cases, and I'm just starting the district court cases. And there may be more that are not captured in the appellate cases. Main question is, was fair use raised? If so, what was the disposition? Did it involve a parody or not a parody? And then looking at some other factors such as who was the decision maker on the ultimate decision, judge or jury, who were the parties involved, what types of parties, individuals, famous individuals, studio, publishers, what kind of copyright did it involve, musical work copyright and or sound recording copyright, and what were the reasons, to the extent that courts ruled on other grounds, what were the reasons given by the court. And then finally, in terms of trying to get a sense of whether this is unusual, I propose to compare other types of works infringement cases with other types of works. And I just picked two that are not the traditional literary works, to go back to Paul Goldstein's hypothesis. Pictorial graphic works and computer programs, which I know are classified as literary works, but certainly not traditional literary works around the time of the creation of the Copyright Act. And basically do a similar analysis to see what percentage of infringement cases in those types of works with decisions have fair use defenses raised. So this suggests around 10% going on in musical court cases, and maybe lower depending if there are a lot of district court cases that didn't have fair use raised. Okay, so that's part one. I'm just going to finish up and open up quickly. Okay, so part two would go back in time to district court pleadings to help capture cases that have settled primarily, to see if I'm not picking up a lot of fair use defenses being raised, but they're just not litigated later on because they settle, drop out. I'm going to Lex Machina from 2009 because that's the date in which they've downloaded the major pleadings in all of the cases in their database, picked up from PACER. I'm doing a similar sort of analysis, and this is a little bit more cumbersome than the Westlaw analysis, so it'll take more time. Okay, so with that, I'll just open it up for questions. Curious to hear. Yes, Matt?
So I'm going to suggest a different methodology.
Sure.
You should get Dotan's registration data, figure out who are the registrants of musical works. You should then cross-reference that against the PACER data on copyright filings, which I've cleaned up and I can give you all the way back to the mid-80s. Then you should try and figure out the cases that might be filed by people who own musical works. If there aren't thousands of them, then you should go through them and figure out if there are, then see if fair use is raised. Lex Machina from 2009 just really isn't back far enough. And if you're just looking at the ones that make it all the way to judgment, that has some obvious problems.
Yeah.
Now, that sounds like a lot of work, but
it might not be, right?
It might be doable.
Okay. No, that's a great suggestion. I'll talk to you more about that too. Yes, sure.
Well, it seems to me as you describe this that, and it would depend on the year of the case, but if the defendant's one of their main defenses is no access, then they're not going to make a fair use defense because that would be inconsistent. So as things have changed over time where musical works are more widely distributed, I think, I would expect, that no access argument would go away and the fair use to come up. So I think there might be a timing issue.
Yeah, and that may explain some of the cases in which maybe fair use might have been put in a boilerplate fashion in the answer, and then it just drops out because they think they're very strong on another ground.
Right.
I would argue that it's considered fairly well established in the music industry that we don't have fair use in music. But
Peter DeCola.
But I did a lot of these cases and it just was understood. But what we do have is substantial similarity, and it doesn't always do a good job. Sometimes it performs better than others, but substantial similarity kind of does the work of fair use in music, and I've kind of written about this a little bit before. I think that perhaps for the reasons that Sharon said, but certainly is the case that, I don't know the Atomic Dog case, but with the exception of parody cases, I think it's kind of understood that we don't have fair use because there isn't a fair use.
Yeah, that's fascinating to me from my perspective, not being in the music world, given that 107 is just written generally to apply. There's no limitation on type of work, and I think we do see it pop up in a lot of other types of works. Maybe architectural works, not so much. I could look at that too. So it would be, I think, interesting to see fair use does not come up in musical works or architectural works if it turns out to be that case too. And what's the explanation for that?
Use, right, but using substantial similarity to do the work of fair use, but not using
as a surrogate, although it doesn't get you all the way, I think, of the benefits of what fair use could offer with this transformative part. Yes.
Yeah, just to kind of second that point, having done these cases on the industry side. Not only does, I agree with that, not only does it really not exist, but when you send demand letters and you make these kinds of points involving substantial similarity, that often will end the discussion right there before you even get to the point where you're going to be going through any cases at all. So you don't even talk about fair use as much as you say, here's kind of what your first slide was. Here's what you've done, all right? And here's what the law looks like. Any questions? So those kinds of industry demand letters, which I did a lot of, are very effective to end the discussion of fair use before you even have more than 4 cases.
Great. Yes, Chris.
So I guess it would be helpful to know more about how you think fair use could come up, right? So at least have some anticipation of what the counterfactuals could be for why they might be missing. Right? Because it seems like in a lot of these cases, what probably happens, which I don't think can happen in some of your other examples, is what people have suggested, right? The plaintiff sends a letter and says these are too similar, and the defendant says no, they're not. And mostly they just negotiate a settlement, right? And the way they can do that often is by adding an authorship credit, right? And so in so many of these cases, they just, add Marvin Gaye, written by, Pharrell and Dick and Gay. And this is not the sort of thing that can ever really arise in like Carew versus Prince, right? There isn't that kind of option for just adding authorship or doing something else, negotiating some other alternative. And so that they're small doesn't strike me, that there's such a small number, doesn't strike me as odd. So I guess I want to know more about why they would be missing, why it would be odd that they're out of the same.
Yeah, although I think it becomes more surprising when it gets past the stage where they don't settle and comply with the demand letter, where they get to the stage of litigation and then your lawyer gets back there and says, what are our defenses? You're not locked in just because you say no access. You can make arguments in the alternative.
But that's when you really hit the problem of selection events. So you've got like 4 cases and they're just the way outliers of all of the times these things ever get raised, right? It's really hard to say anything meaningful about 4 cases where people actually argue.
Right, although we may see a more going on at the district court level. But some of them still need settlement. Yeah.
So I find this curious because I can think of a number of cases that to me actually are cases where fair use was raised in some musical context. So the Zamba case about karaoke, I think, involved a fair use defense. The Dancing Baby case, effectively user-generated content, kind of uses of music where you're giving it a totally different meaning. It seems to me to be an example of that where fair use does quite a bit of work involving musical works. MP3.com was making a fair use defense on behalf of its users, and RIAA versus Dynamo Multimedia was a case in which the Ninth Circuit basically said that space shifting of songs was actually fair use. So if you're going to say those cases don't count, or those kinds of things don't count, then I think you have to narrow down. I mean, even Napster, right, was a case where the claim was that Napster was not a contributory infringer because the underlying, things that the people were doing was sort of fair use within the Sony Betamax case. Now, that was decided against them, but it seems to me that that's actually, I think just to do this and not to sort of see that fair use in fact plays a bigger role. I get that you sort of think that this is different, but at least Zamba should be in there.
So I agree that those cases are out there and they're interesting to know. I think those cases make this seem more anomalous, more surprising, because some of those cases where fair use was a loser argument, like the Napster case or space shifting case, et cetera, whatever. So I'm getting the sense that the industry just doesn't believe in fair use, et cetera, whatever those come up. But those other cases in which defendants attempted to make a fair use argument, which did not involve this pattern of I copied a portion of musical work for my own musical work to transform it, et cetera, whatever. That's the part that I'm just surprised we're not seeing more even non-meritorious defenses, getting litigated to a decision.
So you and I have talked a lot about norms over the years, right? And I think this paper would benefit from having an early section if you could somehow get even anecdotal, I'm not suggesting an empirical study of what the norms are, but maybe anecdotal evidence of what the norms are. I think that might sort of, address some of what Pam is saying and provide an interesting counterpoint to your data.
Yeah, I was thinking, depending on what these results show, of even doing another study, a qualitative study with interviews with music attorneys and representatives in the music industry to get their views on fair use, et cetera.
So a few thoughts. I think Pam's question might be resolved by specifically saying you're talking about fair use in the derivative right, the derivative work right, as opposed to other sorts of copying, which I think is a point you're trying to make, but to sort of narrow it in that way. I agree with Chris about what you think fair use can do. And with that in mind, I have 3 possible hypotheses to add to your list of hypotheses. One is that this is stymied by the inscrutability of music's purpose or meaning. And so it's harder to argue that a derivative work is transformative if you don't know what the original, if you can't guess what the original purpose or meaning is, then how are you transforming the purpose or meaning? So that's one possible hypothesis. Another, and I think this is even more likely, is that the situations where fair use is likely to come up are just less likely to be lawsuits, and not just more likely to be settled, but less likely to be lawsuits at all. And that's because in many musical cultures, quotation and recontextualization of melodic or harmonic elements is not just accepted, but it's celebrated and expected. And I think this is true, for example, particularly in improvisatory music cultures like classical music cadenzas, jazz improvisation, and there's entire genres of jazz music that are all based on the rhythm changes. The same harmonic changes of one song are used in thousands of other songs and improvised over. So I think that sort of, we expect people will copy some things and make new things, so we're not going to sue about that. Maybe a situation. And the third is that one big, I know we're out of time, but one big derivative work area that just won't come up at all is that changing genre, using the cover right, simply isn't actionable. I think we may see more cases come up in the future involving custom arrangement, and that's where fair use, like, we might actually get fair use arguments in that, because that's not covered by the cover right.
Okay, great. Thank you all for those.